Hello, everybody. Welcome to episode 8 of our COVID-19 webinar series. Donna, welcome back.
Thanks, James. This is becoming a habit.
I know. My wife calls us Kelly and Ryan, so I'm not sure. But I wanted to actually start, Donna. I actually have a conflict next week, and you and I discussed that we were probably going to have this series probably go to every other week, as you know, a lot of the information that we wanted to get out we have. So obviously we'll communicate online, but I want to let everyone that's listening know that we're going to take next week off from this particular webinar. But Donna is a shareholder with Becker, and I know many of you have been following us and know her very well. And really what we're trying to do today is continue our discussion of reopening of our amenities, updating our plan, and really dealing with some of the news of the week. There's a lot that's happened this week, Donna, that we're going to get to in a minute. In terms of format, you can chat in your questions. And we had a few hundred questions come in between last week and this week. And so a couple of comments were, you didn't answer my question. So Donna, I think we're going to have to answer more, but in all seriousness, we could never answer them all. So what we tried to do is kind of group them into topics. And so if we don't answer your question specifically, that's why. And I'm amazed, Donna, how many participants are from outside of Florida. I have some from Canada, my home country, and Georgia, and of course we have several communities in Texas. And it struck me that the framework that we've talked about the last few weeks really applies to any geography. Obviously the regulations change, and I know Texas, which we follow, Governor Abbott has really got a little more aggressive than other states in opening up, and he did his executive order GA21 last week. And the reason I bring it up is I think it's very instructive for us to see what's next for Florida by looking at some of these other states that have started to open up and what the sequence is. So we can answer some questions on that. The other thing that's happened in the last couple of weeks is we've really got some experience. We've got some of your clients and my clients that have opened amenities and have had resident reactions, good and bad. And so I think we can share some of those learnings. But before we get going, I want to remind everybody, anything that we mentioned today that you'd like, if it's a document or a link or something, you can email info@casagroup.com. All the past webinars prior to this one are on there as well. If you have any trouble with logging in, just log out and do it again. That seems to be solved all our problems in 8 episodes. And also super important, Donna's been so generous with her knowledge and her brilliance in law as it relates to associations and specifically COVID, but it's really important that I state and you recognize she's not giving legal advice to anyone. So Donna, today we're going to start with updates, and then we've got a lot of questions about the actual implementation of these plans. And then if we get to it, you and I discussed yesterday some possible mistakes that boards have made that they could still fix.
That it's not too late to fix, that's right.
So I hope we get to that. And also, we had a real good response to your ideas last week, Donna, about things that we've learned and maybe we can deal with in terms of amending documents and rules. So we'll get to all that, but really we want to start with what's happening now. And obviously Florida, most of our listeners are in Florida, and the governor has kind of laid out a 3-phase plan, and the whole state is is phase 1, except last week, the 3 Southeast Florida counties. And then, you know, one of the news this week is Palm Beach, but we'll talk about that in a minute. And basically, phase 1 is kind of opening things at 25%. Phase 2 is 50%. And phase 3 will be our new normal. And the other thing that you keep reminding us, Donna, is even though these regulations are changing, it doesn't mean each of our communities is ready to do that. And I'll let you kind of reinforce that, but it's kind of like the floor of this plan as opposed to the ceiling.
And James, there's no reason that that the people listening, the boards in particular, can't pick and choose from a county other than their own. So if there's a provision in another county's order that really makes sense for your community, even if you're not located in that county, there's no reason you can't say, you know what, that particular provision in Broward County's order would make sense for us. And you may be in Palm Beach or Okaloosa or anywhere else.
Well, it really goes back to the rule you've been telling us about every week, and that's the business judgment rule. And if you can't get clarity from your local regulation, looking outside of your county or your state is a reasonable thing to do. So let's jump in here. I think the first news of the week is Executive Order 2114, State of Emergency Declaration. Donna, what does that mean, and what does it say?
Well, are you referring, actually 20.52 was Governor DeSantis's original March 9th state of emergency. That has now been extended until July 7th. And frankly, we have every belief it could be extended beyond then. But right now, we are still under a state of emergency that the governor has issued in Florida until July 7th. And what that means for our boards is you can continue to safely exercise your emergency statutory powers.
I think that's really important. It's, a lot of these questions from our boards is, what can we and can't we do? And that emergency order really increases the options we have as board members. And that executive order I was referencing, Donna, was simply the one that extends 52 out to July 7th. And then also this past week, Executive Order 120, after Palm Beach did some lobbying, I think up in Tallahassee, it sounds like for our Palm Beach listeners, of which I'm already seeing questions come in from them, they get to start phase 1.
They get to open up hair salons. James, you've mentioned a couple times you need a haircut. So
I really do.
you know where we're going with that. But we do have some clarification from Palm Beach County officials with regard to order number 5, which was the community pool reopening. So I'd like to take a moment and read to our listeners what that clarification is, because I think it's crucial. So if everybody recalls, Palm Beach order number 5 basically said community pools shall reopen, and then it listed some guidelines, remember? Well, not surprisingly, there's been a lot of questions and confusions. So we now have a statement from John Van Arnhem, who's the Deputy County Administrator and the Palm Beach County COVID-19 Incident Command. And here is what Palm Beach County officials are saying in response to their order regarding pool openings. We are aware that some associations may not have staff present at their pools and recreational facilities throughout the day. The restrictions on pool use and the supervisory requirements are designed to protect the users of the facilities. The association that is responsible for the pool needs to accept responsibility to ensure that the pool and pool area are used responsibly under the conditions of the order. If that is not possible, the pool should not be reopened. And then the statement goes on to say, because they address the issue we talked about, James, which is, well, if we can't afford to pay for staff to monitor the pool throughout the days and hours of operation, could we get volunteers or could board members serve in that capacity? And this statement from Palm Beach officials goes on to say, with that in mind, it will be acceptable for staff or management to delegate monitoring and compliance responsibilities to board members and community volunteers if they believe the pool can be operated safely and in compliance with the executive order. If these accommodations are unsuccessful, the pool should be closed until alternate monitoring arrangements are made. I think that can't be any clearer in terms of what's expected, and I don't think that can be any clearer about the amount of responsibility that associations are taking on when reopening their pools.
Well, and I think, Donna, as you said earlier, you may be reading from the Palm Beach guidance, but it probably applies to every listener here. They're probably just the first ones that have been so clear. And so a lot of the questions we have coming in here are about pools. And questions like what percent of the pool's capacity can be opened? And if they remove all of the furniture from a pool area, do they still have to follow all of those supervisory rules? Can you talk a bit about some of the nuances of what you just read from a practical sense?
Sure. So listen, not every county has that limitation, James, about reducing capacity, pool capacity. But regardless of what your county order says, your board, if you reopen common pools, community pools in the midst of a pandemic, and we're all looking at the numbers that are continuing to climb, and I think they're predicting now 110,000 deaths by August. Actually, that may be June. There'll be more by August. If you're looking at that, your board's analysis still needs to be, can we provide a standard of due care if we have this pool open? Now, some orders like Broward and Palm Beach, they are requiring a reduced capacity in the pool and the pool deck to be able to enforce social distancing. It's my understanding that Miami-Dade County, when they extend their order this week, that they're going to make it clear that community pools remain closed. But the bigger issue here is the monitoring. Yes, you can remove all furniture. You may want to do that if you're in Palm Beach County. You may want to do that in Collier or Lee. You may want to say, we just don't want our furniture out there because we don't want to have anybody having to clean the furniture after each use. But even if you've got people bringing their own furniture down, you need to mark out where it's at. You still need somebody monitoring the pool, and that doesn't mean monitoring it from the association office by a video camera or, call me if anybody's violating this. This means physically sitting there monitoring it, and that can be an issue for some communities. Also, just because you've removed all the furniture, you still have surfaces where there could be a transmission of the virus, and that includes the gates to open and walk into the pool area. That includes the pool railing for people who are swimming and then clasping onto that railing as they get in and out. In Palm Beach County, we know that it clearly says that showers need to be closed. So the shower facilities need to be closed. If you've got the restrooms opened by the pool, those are going to be routinely need to be routinely cleaned. So you still have a lot of moving parts here, James, and removing furniture is just one issue, which is why I get back to my recommendation I've made several times on these webinars, which is number one, why reopen 7 days a week, 10 hours a day, if that's not manageable right now? You may want to have a reduced number of hours and days that you have the pool operational, so you have people that can truly sit there and monitor the situation.
I think this is important for everybody listening, that if you can't comply with reasonable supervision of the pool, you can't open the pool. And we're using pools as example. Obviously, it is the amenity most people are talking about or most concerned about, but it would apply to any amenity. You mentioned, or we mentioned, or even the gentleman you were quoting in Palm Beach mentioned using volunteers, but I do worry about the liability of to the volunteer and to the association. And you and I have talked offline about insurance coverages. How do you feel about the use of volunteers as it relates to risk mitigation? And would you call your insurance agent before you did something like that?
Absolutely. You've got two issues here. Maybe we can't afford to have a dedicated staff member, but we still want to open the pool or the tennis courts or the shuffleboard court or any of our other outdoor amenities, let's say. So where do you go next? We saw this during the Great Recession, didn't we, James? Where people still wanted to do stuff, but they really couldn't afford to have professionals. So some communities relied heavily on the use of volunteers. Number one, yes, before you even contemplate this and flip the switch, contact your insurance agent to make sure you've got coverage. Under typical policies, there's not going to be coverage for volunteers to serve in that capacity. There may not even be coverage for a director or an officer to do that, because that's really outside the scope of a typical board member's function and role. But here's the overarching concern I have. you're asking people to serve in a capacity where there is a very real likelihood that a dispute or even a physical altercation could break out. What are you sitting there doing? This is not a committee and volunteers that are going out and planting annuals in the common area, okay, where they're not going to get in a fight with anyone. You've got people at a pool or at a tennis court or a shuffleboard court that when they see somebody that's not complying with CDC guidelines, they're getting too close, they're touching, if we're talking about tennis later, they're not adhering to the guidelines and they're sharing surfaces and rackets and balls. What are you going to do? Your volunteer may be inclined to go up to people and correct them. And we all know how well people like to be corrected and told what to do.
I know you do, Donna.
Yeah. I see a real possibility for there to be some danger for volunteers to serve in this capacity unless they are clearly told that their only function is to observe, perhaps take a video or a photo of what's going on, and then go back and report to the board so that the board can get with management and legal counsel to discuss the next step, which is enforcement. But even that, even the simple act of videotaping somebody, as we know, can cause people to get enraged. It could become an issue.
Well, I know we did a whole session on insurance, and so I just I'd like to take what you're saying and then kind of make it really practical for our boards. Obviously, you're allowed to use volunteers unless it's specifically prohibited, and the Palm Beach guidance was an example of that. But there are insurance considerations. You even brought up D&O for board members, and we talked a couple weeks ago about the exclusions from the D&O policies, and in fact revisiting to have perhaps some broader coverage. And then even further than that, we talked in detail about exclusions for the viruses. So there's a lot of insurance implications here, and I think to our boards, all I would say is if you want to open an amenity and if you are staffing it other than by paid professionals, I would consult both insurance and legal advice. Is that a good snapshot, Donna?
Absolutely. But again, I would, look, I think reopening a pool without the capacity to have paid professionals monitoring it right now in the midst of a pandemic may land you squarely in the category of no good deed going unpunished. I really feel that way, James, because you've got people, and here's the other thing. I'm sort of amazed sometimes when you do rely on volunteers that there's not more deliberation about the particular volunteers you're using. Don't use the resident hothead to be your volunteer at the pool. Sometimes the people who are most anxious to serve in that capacity are the least suited for it. If you've got people monitoring, it better be somebody who's good with people.
Yeah, it wasn't my plan to jump into pools, but the announcements in Palm Beach has led me there. So I'm going to go with it because now I'm getting some more questions about pools. What about restrooms? I know most of the orders are saying don't open the showers, et cetera, but can you open a pool if there are not restrooms is the question.
That's an interesting question because we've gotten some statements from the Department of Health that restrooms must be open if your pool is open, okay? Couple things with that. Some restrooms that are poolside have shower facilities in them. So now we've set ourselves up for a conflict in Palm Beach County that if my poolside restroom has a shower in it, I have to close that. On the one hand, the county's telling me I have to close my shower facilities. And on the other hand, they're saying you got to keep your restroom open. Which is it? We can't be walking in the restroom, making sure no one's in the shower. That raises a whole host of other issues that you don't want to get into. We know, James, that there are times that the restrooms are being renovated poolside, and you don't close the whole pool down just because the restrooms are not accessible. So I really think that's a conversation with council to determine whether or not you can close the pool. Again, it's going to be a discussion of, do we have showers facilities inside that restroom? Then maybe in Palm Beach you say they've told us to shut that down, so we're shutting down the restroom. In other counties, it may be we're going to keep it open. But again, this is an area that we need to have cleaned routinely. And I don't mean once in the morning and once at the end of the day. I mean, somebody needs to be going in there constantly and cleaning.
And just so we're clear, because there are counties out there where you can't have the pool open without showers, and then now this ordinance, perhaps in that county, is saying you can't open your showers. Is it true that an executive order would override, a standing law? Like, do we follow the executive order over the standing law of our, a county?
Well, it really depends on the wording of the executive order. So sometimes the executive order will defer, and sometimes it will make it clear that it's overriding it. But I will tell you, based on the orders we've seen over the last 8 weeks, we unfortunately are getting no such clarification. So again, I would urge you, I urge everybody who is working on these protocols to reach out to legal counsel and get a legal opinion upon which you can base these decisions. Because by virtue of getting that legal opinion alone, the business judgment rule is automatically incorporated into your decisions. That way, if and when you're challenged, and I can see our board members are going to be nodding their heads because they all know that they get a challenge more often than not. The decision is we reached out to the appropriate professionals and advisors on which we base this decision.
Okay, and then I've got a questions here about, well, what if only a couple of people use our pool and we don't need monitoring? And I think the answer to that is, if your county says you have to have pool monitored, it has to be monitored whether it's 0 or 1 or 2. The only other one that I really want to, I've got several questions here, and we had this experience at Castle this week where we had an ADA complaint. The pool was opened. The decision of the board was that there'd be no furniture. And someone with a disability complained that it wasn't honoring their disability. And then I've now seen a question on the board here, Donna, where there's a need to use the pool for therapy. So maybe just address the concept of accommodations more generally, as opposed to any specific circumstance.
Yeah, the reasonable accommodation. And listen, we've seen this routinely in shared ownership communities, whether it is you've got a resident who needs a pool lift to get into the pool and use it, the need for emotional support animals and service animals. Of course, we were going to get this question in terms of, hey, maybe you've removed all the pool furniture, but I'm disabled and I cannot bring my particular pool furniture down, back and forth. That's a discussion with council to determine whether or not the person has a disability that would prevent him or her from carrying a chair down to the pool. If my disability is that I'm hearing impaired, I don't think that that's going to prevent me from carrying my chair down to the pool and back. So it really is dependent on what the nature of the disability is. And look, associations have some leeway here. They certainly could say, we're going to bring out, for Mrs. Smith, we're going to bring out a chair and put it out there for her. The problem with that, as most people who are listening will know, is that once they see that that accommodation is being made for Mrs. Smith, they are all going to say they need the chairs out there, that they can't carry them down. So you're going to have to go through the standard analysis of, A, is the person truly disabled? Is the accommodation reasonable? It may not be reasonable to have to accommodate somebody to sit at the pool in terms of violating your protocol, which is we're not putting out the furniture. It may not be reasonable to say we have to pay one staff member just to go and take Mrs. Smith's furniture in and out of wherever, of the locked storage room. So that's going to be a conversation. In terms of the swimming, most of the pools that are open, you can go swimming in, obviously. We had this even when the orders said that pools had to remain closed. Remember that? Now we're in the reopening phase, but several weeks ago, Palm Beach, Broward, and Dade all had pools that were closed. And we still had requests back then saying, I'm rehabilitating from hip surgery, I need to swim in the pool. Again, the answer was that's not a reasonable accommodation in many of our communities. It's closed, it's closed. If they had an opportunity to go elsewhere to swim, they could, but they couldn't do it in their particular community.
Well, let me try and just capture that. I think the best practical advice, Donna, from accommodations is first talk to the person who's asking for the accommodation. The easiest way to work this out is directly. Two, we really need to be careful that we're not kind of setting some precedent. Three, we really need to get advice on this one. But I guess my message to our listeners is, yes, there will be accommodations. They just need to be reasonable ones. I'm getting a lot of questions on...
Well, James, before we jump off that, so when a person needs a pool lift to swim in the pool, we grant it, it's reasonable, but who pays for it? The person who's installing the pool. So one way to skin this cat may be, okay, you need to swim in the pool, otherwise we have the pool closed. Perhaps you require that person to pay for a staff member to sit and clean the pool after use. That may be one issue as well.
No, it brings up the frequency of cleaning, and I'm getting several questions here. And to our listeners, I'm not going to be able to obviously be specific. It depends on where you are. It depends on the rules. It depends on your documents. It depends on the nature of your pool and the size of your pool and whatnot. But what I will tell you is, as an example, the restroom cleaning once a day, which we always did, is not satisfactory. Having the pool actually cleaned by the professional once a day is, but there's still all of the surrounding areas. So frequency has to be increased, and if you can't increase it, you can't open your pool. You're not doing it prudently. Okay.
James, that's going to be a question on an the people listening the boards listening have to understand. Those will be questions on interrogatories. Should a bodily injury result? And the question on the interrogatory at some point that you're going to be forced to answer is, the pool was open from what hour to what hour? Let's say it's 7 a.m. to 8 p.m., okay? How many staff members did you have present? How often did you clean the pool railing from 7 a.m. to 8 p.m.? How often did you clean is there a restroom, yes or no? I mean, when I'm looking at this, I'm already picturing the interrogatories and what those questions are going to consist of down the road.
Well, this goes back to the beginning, and that is that we need a written plan, and that written plan can get as detailed as frequency of cleaning and whatnot. So highly recommend that. In fact, it leads me to, I'm still in news of the week. CDC came out this week with two really, really good interim guidelines. One is on cleaning protocols, and two is for employers. And obviously, we're not going to be able to dive too deep into them, but a couple comments I want to make, Donna. One is on castlegroup.com on our COVID-19 page, we have a CDC link. I highly recommend, I mean, you don't need to go to Castle Group to get to the CDC link, but CDC on their page has a COVID-19 link. And if you hit that, on that next page, you scroll down, there's a guidelines link that gives you all of their guidelines, but there was some really good guidance on cleaning, frequency, and specific product types. So I highly recommend our listeners get that in the hands of their management team and make it part of the plan. I think what's happened with the CDC, and I know not everyone agrees with everything CDC says, but I think they've gotten a lot more granular in terms of their guidance in the last 30 days. And so some of the questions that are coming in about that, I recommend you go directly there. I'm very impressed by the guidance. And a couple of things just high level, Donna. They distinguish between cleaning and disinfecting. They even have some different products. And we've done some research this week, which we're happy to share on some of the electrostatic spray disinfectant machines. And it sounds like, and they're anywhere between $1,000 and $5,000, which sounds like a lot of money. But I believe this new era of cleaning and disinfecting isn't going away in the next 30, this may be permanent. So again, for our boards that are listening, we'd happy to give you some advice on it, but we need to consider what our new normals are in terms of cleaning protocols, and that may mean new equipment and even different staffing schedules.
It's a really good point, James. And again, I hate to beat a dead horse, but I got to hammer this home. Those CDC guidelines are probably going to frame the backbone of potential personal injury lawsuits in the future. They're going to take those CDC guidelines as a checklist and see which associations followed any or all of those guidelines. That's going to form an important basis for these lawsuits. By the way, I don't know if I even mentioned this to you, James. A couple weeks ago, you know, everybody's living online now because we couldn't live outside. And I came across a webinar, a Zoom webinar that a couple of law firms jointly put together about how to sue associations who were violating the transfer fee. So they were charging more than what is allowed by law when units are sold or leased. And there was a whole webinar of, you know, if you live in a condo or a co-op or an HOA, join our webinar and let us know, and we'll tell you how to sue your board for this. And that's on transfer fees. I'm kind of looking down the road with where this is going.
Yes, there will be a whole new industry for this as well. We're getting some more questions, Donna, on signage and waivers and hold harmless, and we've addressed that in prior webinars. But the bottom line is there's no reason you can't put up signage with risk notices, but it's probably not a good defense, and the same with waivers. You want to just briefly recap that one?
Yeah, and I mean, this clarification from Palm Beach County drives home the point we've made, which is those waivers and that signage may be providing certain boards with a false sense of security that they've somehow shifted responsibility to the end user of their amenities. I want to read this sentence again from John Van Arnhem, the Deputy County Administrator in Palm Beach, who said, "The association that is responsible for the pool needs to accept responsibility to ensure that the pool and pool area are used responsibly under the conditions of the order." Now, that couldn't be any clearer to me. I can't now say, well, I posted a sign, I told them use at your own risk, or I got them to sign a waiver and they agreed to use at their own risk. That's not what this order is saying. This order is clearly saying, association, you're on the hook. If you open these areas up and you can't enforce the compliant, you can't enforce the terms of the order, which includes, you know, depending on Palm Beach, you close the shower, you've got staff monitoring, you're cleaning. In Broward County, it's you're not allowing guests to use these areas. If you're opening this up and you can't ensure compliance, the fact that you've used a sign or a waiver in the hopes that you can somehow shift that burden onto the people using these areas, I think that this clarification blows that argument out of the water.
Donna, even though it's Palm Beach written, I think it's applicable to probably every county. How would our listeners access what you're reading from there? Is that on the Palm Beach website, or is that something you've got?
No, this was something that we reached out on behalf of our clients for clarification, and your attorneys should be reaching out to your local county administrators for this kind of clarification.
Okay. Couple more things. I'm still in news of the day, Donna.
And you thought we would have anything to talk about.
A couple things. Hurricane season is now, 18 days away, and there we have potential storm Arthur already off our coast. So we're doing all our CERT meetings this week and next. I just want to remind our listeners that we can't get distracted from what we should be doing every May, and that is making sure our hurricane plan is in place. And in fact, some of the things we're talking about today need to be incorporated into that hurricane plan. And the other thing I wanted to mention, because every community that's listening to this, we have a census that's going on right now, Donna, and that census gets money in our communities. And overall, I think in Florida, we're under 60% compliant. So I just want to do a shout out to all of our community leaders, because they could put it in their newsletters. The more census completion in our communities, the more money comes into our communities. And I just think it's almost more like a public service announcement. But
and do it online. It's so easy.
Very easy to do it.
A minute or two. My
community leaders, I just ask you to put that in your newsletters and get your residents to do that. Okay, I want to just play off a little bit of the, we set up a framework a couple of weeks ago that we outlined for our listeners, Donna, that we basically said, you need to reopen step by step. You need to follow regulation. You need to follow CDC. You need to think about the physical plant. You need to think about staffing. and you need to think about enforcement, and we're going to get some questions on that. But it struck me that we are having some non-compliance, and one of the things I think we can do as a community, Donna, is really almost have a call to arms inside of our community. The fact is, this virus can only spread through airborne or touch. And if we all do these simple, basic things like wear masks, proper cleaning, don't touch our face, social distancing, and no gathering, then we will kill this. And the problems we're having in our communities are people aren't doing that. And we'll talk about enforcement in a bit, but I really think that really this is communication. This is almost selling our residents. This isn't about enforcement or law. It's about, you know, human decency to each other. So I've encouraged our managers, in fact, on a call this morning, overemphasize, rally the troops, our residents, to comply with the CDC guidelines. That's how we'll kill this. And I know we're going to get enforcement in a minute, but any thoughts on really almost proactively communicating so you don't have to enforce?
No, I couldn't agree more, James. No matter what we're dealing with, there's always going to be a certain percentage of people who are hard to bring around, okay? We call them rule breakers. We call them recreational rule breakers. The vast majority of people comply. They get it. They want to get this in our rear view mirror. And the points you made are so spot on. The closer we work together, we can get this in our rear view mirror quicker. But when we've got people who are pushing back and not complying with the protocols, it pushes us back. So I agree with the communication. Also, you're being tested, boards, just like we were with our children. How serious are you about enforcing this? We saw this during the recession again, when some boards were sitting and waiting, and people figured, I don't need to pay my assessments because my neighbor hasn't paid in 3 years and she's still living here. So obviously the association is not foreclosing. It's the same situation here. I've had a couple questions come to me saying, well, we can't enforce. That's not true. What you're really saying is we can't enforce without spending money. That's what you're saying, that we can't enforce just by relying on people's better angels. Well, you're right on that regard, but you absolutely can and should enforce. It's called going to court and getting an emergency injunction, or at the very least, calling your attorney and sending out a demand letter. Don't tell me you can't enforce. You absolutely can enforce. And again, getting back to the business judgment rule, James, courts are going to give you very wide deference. A unit owner or resident who's violating your COVID protocols is going to have a really hard time convincing a judge that he or she needed to violate these protocols and put their neighbors at risk. So it really isn't a question of you can't enforce. It's a question of some boards are saying, we don't want to spend money on this. There is never a time that you shouldn't be enforcing, but this is crucial because we are talking about life safety issues.
Well, you know, this is segued beautifully into the enforcement topic, and I know our boards are struggling with this. A couple comments just from questions I see coming in. There was some question, I think, from some self-managed communities. Can our management team enforce and do the monitoring, and doesn't that create liability? Well, first of all, yes. In fact, the management team or security is the best people to monitor and enforce the rules. Obviously, there's always liability. I can tell you, you know, management companies and security companies carry liability insurance for that reason. But keeping on the idea of enforcement, in a perfect world, we have the staff to have management or security enforce. That's a perfect world. I know we have lots of communities that don't have that. We've already talked about having volunteers monitor and the pros and cons of that. But you and I talked this past week about a couple of enforcement tools in the tool belt that I'm not sure we talked about before. And the first one was suspension of use rights. So talk to me a bit about that tool in terms of enforcement for some of the non-compliance with our reopening plans.
Well, if you still have things closed, threatening to suspend use rights makes no sense because nothing's open. But as we start opening up again, absolutely a threat to suspend use rights related to your violation at that particular amenity might be a huge hammer. And we've talked about this before, James. Suspension of use rights can be a very useful tool, but sometimes, let's go pre-COVID days, we have somebody parking in the wrong space, I send a demand letter, and when I list all the terrible things that we can do to them, I may list, well, we can suspend your right to use the pool or the fitness room or whatever. And sometimes those people don't care because they don't use the pool and they don't use the fitness room. So it's somewhat of an empty threat. But in this situation, when we're talking about COVID-19 protocols, if the person is a violator because they're violating your pool rules or your tennis court rules or your gym rules, now we know that we have a bigger stick because we know that person uses that amenity. The question here is, can we exercise our emergency powers to immediately shut off that person's fob, assuming we have access control, or do we have to go through the 14-day process? I would urge you to get a legal opinion on that. I know my approach, which is rather aggressive because we're dealing with life safety. And again, courts are going to give really wide deference to boards who are making these decisions. And whether or not you can wait 14 days when someone is putting others at risk is highly questionable, in my opinion.
So I think to our listeners, that's a very interesting, when we didn't pay our maintenance back in the Great Recession, sometimes we got our remote access, you had to go through the guard gate and whatnot. Here's a tool that would be pretty effective to your point. The other one is, look, we're going to open up our amenity based on the rules and best judgment. And these are the rules. And if residents, you don't follow the rules, we're shutting down the amenity. I would think that would be pretty high leverage as well.
Pretty high leverage. And in the demand letters I've written, I've let people know that if we have to shut down the pool because you are violating it, we're going to let people know who you are and that we're shutting down the pool because you're violating it.
We have a few more comments. We've got owners saying we're not going to pay our maintenance if you don't open our amenities. And we've addressed this in prior episodes, Donna, but it's interesting that we said at the beginning of this, no, you can't hold back your maintenance and you don't adjust the budget. The budgets are done for a year based on a best estimate. And here we are now possibly having to incur more expenses to staff these amenities. So there was really good reason for not lowering maintenance, but quickly, because I know the answer is obvious, anyone that doesn't pay their maintenance because an amenity is not open is going to be right into the collection process.
Guys, there's case law on this. By the way, over the years, I have represented individual unit owners in disputes against associations. My main representation is obviously association representation, but I think it's important to occasionally take other cases so you understand both sides of the fence. And the first thing I would tell an owner who said, I want to stop paying, was don't do that. If you have a legitimate claim on something else, you can always bring your own cause of action. But the last thing you want to do is stop paying your assessments, because once it goes over to you're going to get interest, you're going to get late fees, and once it goes over to the attorney's office, you're going to incur substantial attorney's fees and costs. So what may start out as a $300 debt could wind up being a couple $1,000. That's the last thing you want to do.
And you're going to lose.
You're going to lose, because the only defense to not paying your assessment is you already paid it and you have proof you paid it, or you didn't get notice that the assessment was owed. Other than that, failure to maintain, failure to use it, none of that constitutes legitimate affirmative defenses to a Florida foreclosure action. And I'm sure that's the same in other jurisdictions around the country.
Well, that always leads us to the question we often get is, what do we do about collections and late letters and whatnot? And our guidance from the beginning has been stay the course exactly as normal. We actually had a few of our communities that did not issue reminder letters in April, and now we're stuck in May, and what do we do? And if you don't remind them in May, at some point you're actually jeopardizing the collection process. So has anything changed in your advice on stay the course on collections, Donna?
Well, first of all, you have to look at your individual documents to see what the policies are. When does interest and late fees start accruing? When is a payment deemed delinquent under the declaration? So just because you missed a late letter doesn't necessarily mean that you can't proceed to collect that delinquency. That doesn't mean the person's not delinquent and the payment's not owed. I like the advice to stay the course. And I'll tell you what, I've had a couple of communities, James, where questions have been asked, well, are you going to wait? Are you going to reduce the assessments? Are you going to waive blanket waiver of interest and late fees? I kind of analogize this to all the entities that went out there and took PPP loans when maybe they didn't really need it, but they're asking, again, that falls under the category of nothing ventured, nothing gained. Boards are going to get these questions sometimes from people who don't need it, but they figure, I'll ask. And if I can get it, that's great. That's not to diminish the people in the community that truly are having economic issues as a result of this pandemic. But not every request is coming from somebody who needs that relief.
Speaking of PPPs, if any community did get it and didn't need it, they have till the 14th. There's a safe harbor provision in that SBA law. I just want to, because we're going to run out of time as we always do, Donna. We kind of talk a lot about pools, but I want to briefly hit on tennis courts and then other amenities, if I could just kind of put that all together. So tennis, most of the guidance is you're open to singles. We've had a lot of questions from our own clients saying, well, in our 55 plus communities, physically that's not ideal. And I know that some of our pros have done a great job of just restricting the court, whether that's just playing half the court or diagonally, the deuce and ad court. All that to say, basically all guidance is for singles play, and for those worried about the physicality of it, we've come up with some great ideas about how to just reduce the size to address that. So any comments on tennis?
Yeah, I get the same questions. I've had this conversation with numerous clients, which is, we talk about how the USTA, which is the U.S. Tennis Association, has released these guidelines, and they're saying singles play is fine. And they have guidelines in terms of different cans of balls for the players so they don't have others touching the same surface. Doubles play is not yet recommended. But then I get the pushback, which is, well, we have an elderly population and they need to play doubles. So what you're telling me is you have a vulnerable population who's vulnerable to this particular virus, but you're allowing them to play doubles play. You have to start thinking, like, I hate to say this, like a personal injury attorney, because the UST guidelines are going to be up there in a giant graph, and your only excuse for allowing a doubles play to take place is going to be, well, our people were too old and vulnerable to play singles, so they needed to play doubles in violation of these guidelines. I guarantee you the people looking to pursue these kind of claims are the ones that are going to be looking for all those guidelines that are out there with regard to this. And James, I have to jump in because I know we're going to run out of time. Contractors, I'm getting a lot of questions about loosening the guidelines for renovations inside the units. In some of our Palm Beach communities, they allow remodels to happen starting at the end of May or beginning of June. It just came to my attention that there's a 92-year-old Palm Beach condominium owner who has filed a lawsuit against his board because they loosened the construction protocols. And he's concerned because he thinks it puts him and other neighbors who are also in his category in terms of age and underlying health conditions at risk. Your board is going to be subject to criticism and potential litigation either way you go. So you have to weigh the risk between what's the risk in you not being able to sign a contract and remodel now versus what's the risk involved with bodily injury. Should we allow this and an elderly resident who never leaves their unit basically contract this disease?
Okay, I have a couple of community access questions to come back to, but I want to put a pin on amenity usage. Just going to do some quick hits here. We're being asked what percentage of castle pools are open. Those that are allowed to open, the majority are open. What about restaurants, and what about ballparks, and what about other parks? And Donna, our guidance on this one is if you can have social distancing, no gathering, of more than 10 people. In other words, if you can follow all the CDC guidelines and your local regulation allow it, there's a way forward for that. And that should be part of your plan. Any further comment on just kind of, if it's not specifically addressed in executive order, our guidance is, as long as you can actually do the activity, like basketball is one where you can't have a game because you're touching each other, right, but you play horse.
Right.
So
I couldn't agree more. It's not just the space. A lot of people are always thinking, well, we can spread out here. It's the activity. So if you have, I've got a couple communities where they have just an abundant number of amenities, horseshoes, pickleball, they've got shuffleboard. You should have people purchase their own equipment, or they're going to have to forego the activity. But for the association to be supplying, one is bocce ball. Remember, you talked about surface transmission. Have to think about the activity. Is this something where people can bring their own equipment and they can play social distance? In terms of a one-on-one basketball game, you can't safely do that right now. Horse, some of the counties have actually said, yeah, we can safely permit that activity. And again, folks, this isn't permanent. This is temporary. A phased reopening should be phased, which means you should slowly loosen up over time once you see what you can manage and you have time to problem spot any issues.
Yeah, in fact, one of our recommendations, I wouldn't say recommendations, we've had some issues. We really need to satisfy the residents that it's going to happen. So we've said, well, if it's allowed to, but you're uncomfortable, but you think you will be comfortable, like they did in Texas this week, they on May 6th, they allowed certain openings, but some was on the 8th, some was on the 18th. So you can actually announce a phased, even by putting some dates into it. One more I want to hit before we move to access is we have at least 30 of our communities have food and beverage. And I will tell you that assuming, again, that your county allows it, there's no reason you can't do takeout. And I was in Tampa last week, Donna, and you should see how many restaurants outdoors, every 10 feet they have a table, and every one of those tables was occupied. So again, subject to your local regulation, yes. In fact, we have some best practices that we're happy to share on reopening your food and beverage.
Yeah, and I assume on food and beverage that, number one, there'd be no in-house eating, no in-house dining. If you want to do takeout or you want to do an outdoor seating where Correct. You can keep them space. And I would assume that the servers and the food preparers are wearing protective gear.
Yeah, in fact, we've had some questions come in here about wearing masks and whatnot. And, you know, I'm not giving legal advice. I'm just saying my practical advice is, yes, always wear masks. Like until this thing goes by us, I live in a high-rise personally, and I don't leave my condo without my mask on. I mean, it happens to be the rule in our condo, but I would do it anyways. On access, a couple of quickies. Number one, really at this point, we're still resident versus guest. You know, it's not that we won't be able to open up a guest at some point, but for this whole discussion we've had about amenities, really our management advice at this point is keep it the resident only. Thoughts, Donna?
That's my legal advice too. The fewer people you have using your reopened amenities, the smaller your difficulties when it comes to monitoring and enforcing social distancing. I just see no reason to permit guests at this point. Again, I keep saying this, it's probably going to fall into the category of no good deed goes unpunished. I know boards they're very cognizant of the fact that their residents have been pent up, and I get that, and it's great to be sympathetic. But you can go too far in the other direction. For right now, in terms of your community's phase one opening, I don't see where, actually let me reverse that. I see where guest usage can put you in peril, particularly if your county says no guest usage. You shouldn't be doing it, period.
And then, you know, you addressed quickly contractors, realtors, move in, move out. What we're seeing is keeping fairly high restrictions on contractors, allowing move-ins and move-outs. And the realtors have actually been really good doing a lot of virtual work. So I don't know that a lot has changed between last week and this week in terms of your and my discussion about access to the communities. That isn't something that we see, you know, loosening from last week to this week. Is that fair comment?
It is. I mean, look, in an HOA where you have single family homes or even detached townhomes, absolutely at this point you can certainly be managing contractors and realtors coming in. In some instances, you may want an indemnification from a particular realtor or a contractor, just to make sure that you're going to be, that the association is going to be protected in terms of the size of crew that they send, in terms of protective gear that they may be required to wear. So some associations we're discussing indemnifications agreements for those, what we call non-essential guests to come in. But still, if you're dealing with a multifamily building, in some cases we're saying if you want to do the remodel and you want to do the construction, your contractor is going to need a scaffold and going to need to be accessing your unit from your balcony in, as opposed to going through the building. There's a lot of different ways that you can set this up where you can loosen up the restrictions a little bit while still not putting your residents in jeopardy. And James, I know we didn't get a chance to talk about the amendments, which are so crucial, but all of the things, all of the problems or questions that you're experiencing now as a board or as a management professional, we can address most of these in amendments moving forward. For example, we could amend your documents to say that if somebody wants to move in the midst of a medical crisis or pandemic, that we can charge you for the cost of doing so, and we can specially assess you for those costs. We could incorporate all the emergency powers under the statute into your documents, so we don't have to sit on pins and needles waiting to see how long that those emergency powers last. We can deal with that in your documents. There's so much we can do in your documents on a going forward basis that will answer most of these questions and problems you're having.
Really good point. In fact, I think, Donna, in the next month, we'll do a whole session on just what we would consider as changes. It would so much help our boards to deal with this situation. And for all we know, we could have a recurrence this fall. So I don't think this is a way out in the future thing. I think we're going to have to sit with our attorneys, go through what worked and didn't work from an enforcement point of view, and let's get our documents and rules and regulations amended this summer.
And that's when, just one final thing, that's when you get the inevitable pushback from your community, where's your authority for this? And they're interpreting, local orders the way they want to interpret them. Your answer is it's in our governing documents. Exactly.
Because we're running short on time, as always, I wanted to mention one other thing. We get a lot of questions here, Don, about employees. And one of the things that we obviously guide us by law are the OSHA requirements. And OSHA did not change their rules, but they did put out a really nice recommendation link. In fact, let's get that up on our website. And especially, obviously, if you're managed by a management company, they can provide you that guidance. But if you're in a self-managed community, it's really nice to see that OSHA has given us some help on how to deal with this situation from an employee point of view. So Donna, we're here at 1 o'clock, and the one area we didn't get into was mistakes that we could make and do some fix. But I've read them here, and that's another half hour. So I think looking forward, we'll continue. We're gonna do this 2 weeks from now on the 27th. And we're going to obviously give you the updates of the day, which we had a lot today. And also, I don't think it's urgent, but this whole idea of what we can do with our own documents, rules and regulations, and what mistakes have we made that we could actually fix right now. I think that's almost a whole session.
Absolutely, but because we're going to take a week off and a lot can happen during that intervening period, one mistake you can fix right now is if you feel that you reopened too quickly, okay, you can close it. If you feel that you reopened too quickly and you can't manage it, you can revise the hours of operation and the days it's opened, and you can get a combination of paid staff, volunteers after you contact your insurance agent and make sure you have coverage should something happen to those volunteers while they're monitoring. But I would say, James, that's one mistake that they can fix right now if they felt that they've reopened too quickly. Or if you still have your pool closed and you're considering reopening, get a legal opinion.
Yeah, we should kind of end with that. We're having a discussion, Donna, you and I, and I'm giving management advice, which I'm kind of allowed to, and you're allowed to give legal advice, but we don't know how applicable that is to each of our listeners. But I will end by saying that I know you, the boards of directors, had no idea what you were getting into when you put your name up. And we know the pay is terrible, but your leadership and your support of all the management teams, and we're just hopeful that these webinars are giving you some good questions to ask your management or your lawyer, and you should make sure, especially, we know there's going to be some litigation later, that everything we do, we're doing with the appropriate advice. So I'm going to end with Donna. Thanks to you. I'll see you in 2 weeks. And to our listeners, thank you so much for leading. It's amazing what you're doing, and we hope these webinars are helpful. So be healthy, and we'll talk to you in 2 weeks. Thank you.
Thanks, everybody. Be safe.